Welcome, everyone, to the Federal Bar Association Ketam sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am chair of the Ketam section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So we had a lot of action here in the U.S. Courts of Appeals in the FCA space as the summer wrapped up. Let's start with United States ex rel. Sibley versus the University of Chicago Medical Center. This is a case from the U.S. Court of Appeals for the Seventh Circuit, and it dealt with the proper pleading standard for employment retaliation claims under the False Claims Act. How did the Seventh Circuit come out on this one?
Yeah, this is an interesting case, Scott. It actually deals with that issue and also the Seventh Circuit spin on Rule 9b, a topic that's currently percolating up before the Supreme Court. So in this case, the relators are folks who worked for medical debt collection businesses, and they allege that their employers violated certain rules relating to when you can go after bad medical debt. And the Court of Appeals reaches two holdings. First, it says that as it relates to the direct false claims allegations against the employers, the employees did not do enough to satisfy Rule 9b because they didn't provide representative examples of the bad debts. That's with respect to some of the defendants. For one of the defendants, they had the examples, and the Seventh Circuit says case is fine. Then the court gets to the question of, do retaliation claims also need to be pleaded with particularity, because retaliation, at least arguably, is not a fraud claim. Maybe Rule 9b doesn't apply. And it joins the consensus of circuits that say you don't have to plead retaliation claims with particularity, and allows those claims to go forward in this instance. It's not an earth-shattering ruling, but it is making new law in the Seventh Circuit, which is, I think, why the decision was published. The slightly more interesting part of the case to me, though, is that the Seventh Circuit, I think, previously was regarded as one of the more permissive circuits on Rule 9b for direct false claims. But here, the way they phrase the standard sounds a little bit more restrictive. And so it's interesting to see them kind of in the middle there. You wonder if it's sort of a panel-dependent thing, what standard you might get in any given case.
We now turn to United States ex rel. Hartpence versus Kinetic Concepts. It's an opinion issued by the U.S. Court of Appeals for the Ninth Circuit. And in this case, the Ninth Circuit addresses when a false claim is material to the government's payment decision. It's something we've covered before. Tejinder, is there maybe a consensus forming in the appeals courts?
I think so. This is a case where it's a really good example of a case where you can see the court going through the issue in a summary judgment posture and showing how when evidence cuts in different directions, you're probably not going to get summary judgment for either side. And so what happens here is that the defendant is using a modifier in its billing codes for wound care. And the gist of this modifier is when you use it, you are effectively certifying that all of the prerequisites for reimbursement have been met. No need to look further into this claim, just pay it. That's functionally what the modifier does. And so the defendant is using this just pay me modifier on claims where it knows the claims are not necessarily fully eligible for payment. It's kind of taken a position that the claims ought to be eligible, but it's been told by the administrative contractors that they're not, and it's using the modifier. And so the court below said, well, yeah, that's a false claim, but the government often does pay for these things, even when maybe not all the criteria are totally met, so it's not material. And the Ninth Circuit reverses. It says, look, in this circumstance where they're using this modifier, they're bypassing the review process. The only way they could win is by showing that when the review process actually happens, the government is always paying the claims even when these criteria are met, and they haven't showed that. And the court actually goes through the evidence and finds examples where the government has refused to make the payments, and it says, therefore, the false use of the modifier is going to be material, and the defendant should have known it was material, and so sends the case back.
Our next case is United States ex rel. Silbersher versus Allergan, also from the U.S. Court of Appeals for the Ninth Circuit. And here, for the first time, the Ninth Circuit publishes an opinion about the public disclosure bar. What did it say?
Yeah, this one hurts. This one, I argued this case for the relator and it did not go our way. This decision is the first published decision in the Ninth Circuit interpreting the amended public disclosure bar, the 2010 one. And the specific question before the court is whether patent prosecution proceedings count as a federal hearing that falls under the scope of the public disclosure bar all the time, or whether they only count when the government or its agent is a party to those hearings. And it has to do with the kind of technical question about which prong of the public disclosure bar appropriately covers these proceedings, or whether both do. And what the Ninth Circuit ends up saying is it ends up saying effectively both do. That is, basically every federal hearing, whether the government is a party or not, if it's for the purposes of gathering information, is going to be covered. And they characterize patent prosecution that way. The decision tees up a little bit of a split. The District of New Jersey adjudicated the exact same question and came out the other way. But I think the more salient point for most of the viewers is actually just about the interpretive approach the Ninth Circuit takes to the public disclosure bar. Among other things, it takes this language from the Supreme Court's Schindler elevator case, which observed that the public disclosure bar has a generally broad scope. And it uses that language to interpret the amended public disclosure bar. Now, the reason that's a little slippery is because that language is describing the pre-amendment disclosure bar, and Congress specifically amended it to narrow it. And so the idea that you would take this language that says we interpret it broadly, and then Congress narrowed it, and you're like, yeah, but it still counts. I'm not so sure about that one. And there's a couple of other things in the opinion that will actually bring a rehearing petition to see if the Ninth Circuit will take another look at them. But so far, what you see the Ninth Circuit taking a relatively broad and defense favorable view, even of the amended public disclosure bar. It didn't pass on the original source exception, which is another provision that changed substantially in 2010. So we still don't know exactly what the Ninth Circuit thinks about that, but we may get further clarity on that in the next several months or a year or so.
Let's take maybe a deeper dive on our last case, U.S. versus Honeywell, a decision from the U.S. Court of Appeals for the D.C. Circuit. It's a non-QTAM FCA case, Tejinder, and it presents for really the first time this notion of Honeywell seeking a dollar-for-dollar offset for money that other entities had paid the government as part of a settlement of a fraudulent scheme. How did the DC Circuit panel come out on this one?
Yeah, so this is a case arising out of the sale of defective bulletproof vests to the government. There was this line of vests called the Z-Shield. And there was a manufacturers that made it, and then Honeywell purchased it and sold them to another contractor. It sold the material to a contractor which incorporated into the vest and sold it to the government. And so Honeywell was kind of in the supply chain, but it wasn't the only entity in the supply chain. And all the other entities that were relevant had settled with the government, paying the government damages for false claims relating to these bulletproof vests. And so the question that Honeywell raised in the district court is it said, hey, government, you've already gotten money from the other defendants. You've effectively actually been made whole on the damages. We want a summary judgment ruling that we don't owe you any damages. Even if you win that we're liable, we don't owe you any damages. The government took the position that the proper mechanism here is what's called a proportionate responsibility approach to damages. That is where each defendant should be forced to pay damages in proportion to their culpability as it's determined by a finder of fact. The Honeywell approach is called the pro tanto approach. They get a dollar for dollar credit for every dollar paid to the government. The district court denied Honeywell's motion. It went up to the DC Circuit in an interlocutory appeal. And Honeywell prevails on that appeal. It convinces a panel of the DC Circuit that it's entitled to a dollar for dollar credit against any of its liability for damages already paid in the settlement, which means even if the government wins against Honeywell, it gets no damages. And it should be clear to bracket this that's distinct from civil monetary penalties. So the government does still have a live case against Honeywell. It can go forward. If it wins, it can get civil monetary penalties as mandated by the False Claims Act. But what it can't get is any additional damages.
So what it means for Honeywell is, as far as paying up, they're not paying anything to the government on damages at all.
That's right. Their worst case scenario on damages is now zero. If everything goes as bad for them as it possibly could at trial, they still pay no damages whatsoever to the government, which is kind of an interesting result, right? The government took the position that, hey, part of the point of the False Claims Act is to deter fraud. And what you would be doing here is you would be allowing Honeywell to skate, even if a finder of fact deems them very culpable for the damages to the government. And the DC Circuit effectively said, yeah, we understand that point, but we actually think the equities on balance favor the other approach, that is, of giving them credit as opposed to allowing the government to claim a windfall and extra damages here. And part of what drove the court, and this was interesting, this is actually a fact that I learned while reading this decision, is that there is no right. The DC Circuit says there is no right of contribution in FCA actions. So if you have a situation with joint and several liability and a defendant gets found liable, but the other defendant's culpability hasn't been adjudicated, the way that works in a lot of tort situations is the defendant that's found liable can then bring contribution actions against the other defendants and try to get them to pay their fair share of the liability back. It still has to pay the government all the damages, but it can get something on the back end from the others. Here, that's apparently not permissible. And so part of what's driving the DC Circuit's decision is it says, look, there's no contribution right. It kind of signals that every defendant is going to stand on their own vis-a-vis the government, but also it shows that the defendants aren't pooling their liabilities. And so what we're really looking at is, did the government recover? And once it recovered, it can't get more in the damages pool anyway.
So what does this mean for settlement in multi-defendant cases where the government is trying to get folks to come forward and to pay their fair share?
Well, if I were a defendant and I were looking at this ruling and I had the wherewithal to litigate and I thought that I might be deemed quite culpable by a finder of fact, I would say, let's not settle. Let's see what everyone else does. Because if any of my co-defendants settle, they are also buying down my exposure for me. I have no further exposure to any damages that the government gets as a result of a settlement. And so I think it creates really strong disincentives to settle for defendants that are relatively culpable and relatively well-heeled. You know, if you can afford to keep fighting, the expected value of doing so went up as a result of this decision. And I think that may also alter settlement discussions in terms of people's willingness to come in before other defendants come in. It may really complicate some of these discussions going forward.
So one of the other interesting wrinkles was that the panel invited the government to negotiate on statutory penalties, something that the government traditionally doesn't do. We've seen a few cases, Tejinder, where courts have blessed very large penalty amounts versus the underlying damages. What do you think this might do for the government in terms of pushing the government to maybe negotiate on statutory penalties?
Yeah, I wouldn't presume to know what the government's going to do, because to be honest, it's always been a little bit perplexing to me that the government doesn't afford penalties a higher place in the calculus when it figures out the value of a case. There are lots and lots of cases where the damages are likely to be swamped by the penalties. You just think about cases involving, for example, hundreds of thousands of prescriptions that are all tainted by a kickback scheme or something like that. The value of each individual prescription may not be that high, but you know, if you've got a $10,000 penalty attached to each one, you start to get to real money before too long. And the government, you're right, the government has not traditionally prioritized that. I do find it odd that that's true. And I do think that if the damages remedies are limited, and part of the rationale for limiting the damages remedy is, hey, government, you still have the penalties, then it behooves the government to take seriously the idea of penalty exposure when it goes to the settlement table or has any other conversations with a defendant about the scope of their liability. I think penalties can and should play a bigger role in the discussion. But of course, ultimately, that's a matter of government policy and how they want to figure it out and value their cases.
Let's finish up with just a quick turn to what's happening at the Supreme Court. Can you give us a quick update, Tejinder, on what we can expect this fall?
Sure. There are 3 cases or lines of cases that are currently drawing a lot of attention. The first is the Polanski case about the government's authority to dismiss FCA claims over a relator's objection. That case is currently being briefed. The argument's going to happen in November, and we should have a decision out probably early 2023. There is a set of cert petitions about Rule 9b that I alluded to a little bit earlier. The most recent development in those cases is that on September 9th, the government filed a brief in a case called Owsley, where the court had invited the views of the Solicitor General. The government recommended denial of certiorari. And so the court is going to be considering those petitions in a few weeks, and we should know probably by the end of October whether they're going to be hearing those cases or not. And just as a disclosure, I represent the relators in all 3 of the cases that are currently up before the Supreme Court on that question. And the third question that's kicking its way around is the scienter question that's brought up by the SuperValue and Safeway cases. Those cert petitions have been filed. The court has again called for the views of the Solicitor General. We don't yet know when the government is going to file its invitation brief, so I wouldn't expect any action on those petitions for several months. But by the end of this upcoming Supreme Court term, we will know whether the court is going to be taking up the SuperValue Safeco scienter question as well.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association Key Tam Sections, The Rounds, FCA News with Tejinder Singh.